We are on the record.
May I confirm who's on the phone, please, before we proceed?
Judge, this is Alan Kessler for plaintiff myself, bar number 150209.
Okay, and for the city attorney's office?
Hi, Judge Thatcher. This is Mark Rodriguez on behalf of the city, bar number 201019.
Okay. All right.
And Judge Thatcher, I am also on the line. Nice to hear your voice. This is Tony Garcia, bar number 061570. My colleague is handling the case today, but I am on the line.
All right, that's fine. I'm going to make you go through that again in a minute as I call the case. This is the time and place set to hear defendant City of Portland's motion for summary judgment in the case of Kessler versus City of Portland. The case number is 21CV06317. I'm now going to ask counsel to identify themselves for the record so we can proceed. Mr. Kessler?
Yes, Your Honor. This is Alan Kessler. I'm appearing for myself, bar number 150209.
Okay. And speaking for this city today?
Hi, Judge Thatcher. This is Mark Rodriguez, speaking on behalf of defendant City of Portland, bar number 201019.
Okay. You folks have asked for a fairly substantial amount of time for this argument, but I have very carefully reviewed the papers submitted to me from both parties, and there are a couple of matters I want to clarify. One procedural matter before we proceed to discuss the substance of the case. I have the city's motion, and in response, Mr. Kessler filed a cross motion for summary judgment, and officially, therefore, there is additional time for response and reply. The city, for instance, has not responded to that cross motion except insofar as it filed a reply brief in support of its initial motion. Having read the papers that the parties have submitted and reviewed the record, it is not at all clear to me that more paper would be either useful or necessary. So I would make the following proposal to the parties on how to deal with this situation, and then I will ask each party to let me know if they find that proposal acceptable or if they want to suggest something else. My proposal is as follows. I would propose to hear the city's motion and Mr. Kessler's argument in opposition today. If I decide ultimately, after considering the arguments and taking the matter under consideration, as I always do, I don't typically rule from the bench. If I decide to grant the city's motion, I will also deny the cross motion because I think the briefing is substantial and is adequate. If, however, I deny the city's motion, that then leaves the cross motion to be determined. And in that case, I would either grant the cross motion, since I think that this is a matter that can be disposed of in that manner, or I would direct that the parties approach the court and seek a subsequent hearing on the cross motion. Because I believe that the matters are primarily legal, that may not be necessary. But I think it would be important at this initial stage to leave that option open. So essentially, I'm proposing sort of a hybrid that I will consider both motions now, but if I consider that additional briefing is necessary, having denied the city's motion before the cross motion can be granted, I would direct the parties to seek additional briefing time. So that may not be the best way to do it. It is one way to do it. It's the way that I thought of as I was thinking about this week. So, Mr. Kessler, since you were the one that brought the cross motion, why don't you let me know your reaction to the proposal I make?
Your Honor, I agree with you, and I actually didn't. I didn't file a reply to the response on purpose because I didn't think there was anything new to say. So I'm completely fine with your proposal, Your Honor.
Okay. Well, it's then to the city, please. Mr. Rodriguez?
Just Chair, the city also agrees.
Okay.
And then, thank you for your consideration of that.
Okay. Well, thank you all for your willingness to proceed. So now let's move to the next step. And as I said, I've read these papers carefully. I've reviewed the law. I know the Open Records Act to a certain extent. And rather than just simply, since I've read your papers and they are thorough, here's what I propose. I tentatively propose to grant the city's motion, but that is a tentative decision. And I would propose that in the next few minutes, I will first let Mr. Kessler make any arguments, additional arguments, or focused arguments that he may have to tell me that that tentative decision, which is based very much on my analysis of District Attorney Rod Underhill's decision. Mr. Kessler can tell me why I shouldn't do that. And I will listen attentively because this is only a tentative decision. After he explains to me why that tentative decision is wrong, then I will give the city some time to respond and tell me to Mr. Kessler and explain why their motion should be granted, why I should turn a tentative thought in my mind into a final decision. But I do want to emphasize that I have carefully reviewed everything. So I don't need repetition, but I appreciate any emphasis that you want to, or any focus that you want to place on the arguments you've already made. So, Mr. Kessler, you have the floor.
Thank you, Your Honor.
To explain the situation from your perspective.
Thank you, Your Honor. So in the summer of 2020, I was following along with the protests, and I had people approaching me asking me who this particular officer, number 12, was, because he was acting extremely violently. He was shooting at people's heads. He was popping tires of cars that seemed to be not engaged in any sort of criminal activity. He appeared to be
okay. Let me interrupt. From a distance, I followed the protests. The city gave me all sorts of information which was irrelevant. That is,
Okay.
They told me what they thought their police officers were facing. You don't need to tell me about whether or not there was one or more officers who were acting improperly.
Understood.
The question here is and I don't mean to dismiss either your concerns or the city's concerns. Let's focus on what you asked for, how the city reacted, that is, responded to your public records request, and whether the city has complied with the law. That's really where we're at.
Thank you.
I know there were problems in the streets of Portland over the summer, and whoever was responsible for the problems, that's unfortunately, or fortunately, actually fortunately, not my concern. So go ahead. I'm sorry to interrupt, but
no problem.
I want you to be able to get to the legal arguments.
The background I was giving you was to say that there was this person who's wearing number 12, a 2-digit number, and there were other individuals wearing other 2-digit numbers that I was interested in knowing who they were, because as the picture in the complaint shows, this number 12 had covered his nameplate, which is required by his uniform. So I, and I didn't know what number 12 was. I'm a member of the public. I don't have any special access. And it looks to me like that must be some sort of internal personnel number, lowercase letters, generic description for, he's personnel. That's a number. That must be a personnel number.
Okay.
And so I asked for the internal personnel numbers that were being worn as badges, essentially. So the request was for those, whatever the numbers were that were being worn. I got a pretty, from my point of view, disingenuous response from the city. They sent over a memo that said, we've authorized officers to use PERNers, personnel numbers, capital letters, something that they internally call personnel numbers. And they, in my view, cynically ignored the language in my request that says worn by officers, and simply limited their analysis to those PERNers, because they said you use the word personnel numbers, those are magic words of the city, so therefore you must have guessed the thing that we have internally that you didn't know about, and that must be all that you meant.
Okay,
it should have been clear.
Just to look at your request, you asked for documents that correlated the internal personnel numbers used in lieu of badge numbers or name tags on police personnel during the demonstrations. So you seem to know that there were some sort of numbers being used in lieu of badge numbers.
Yes, because I saw photos. Yes, Your Honor.
Okay.
So I saw photos like the photo in the complaint of people wearing these 2-digit numbers on their chest and sometimes on their helmet. And it was mostly 2-digit numbers. I don't remember seeing any 6 or 7-digit numbers at that point. Later, the city started using 6 and 7-digit numbers, which I understand now to be the PERNers, the personnel numbers that the city was referring to. So that's the first reason why I disagree with your tentative decision. The city limited its entire analysis to those personnel numbers, the PERNers, capital personnel numbers. And I think they ignored that the generic meaning of the request that I put in would have covered those 2-digit numbers, which I only this week learned are called RRT numbers from opposing counsel. So those were the internal personnel numbers for the rapid response team, is why they're called RRT
I'm
numbers.
sorry. What you said you learned from opposing counsel that something is an RRT number?
Yeah, so the 1 and 2 digit numbers.
Your Honor,
I'm
sorry, Mr. Kessler, I think I need to interrupt because anything related to that conversation was subject to a 408 under the Oregon Rules of Evidence settlement communication. So
okay.
I think that's privileged.
Okay. All right.
Okay. So officially, I still don't know what those 1 and 2 digit numbers are called. I suspect that they're internal numbers that associated with some group of personnel at the city. And that's what I was trying to get at with that records request, primarily. The city sent this memo about the PERNers, which to my knowledge, they had not used at the time, at the time I sent my request. I'm not sure that any officers had been on the street with those PERNers. So in that sense, that memo was potentially non-responsive. And when I went to the district attorney, I included a picture, the same picture that's in the complaint. So the city should have known that my request, the language of my request was intended to get at those 2-digit numbers. They knew the whole time what those numbers were, but they continued to pretend as though I was asking for capital R personnel and personnel numbers as they define them internally. So for that reason, their entire appeal to the exemption as to employee-issued identification card numbers is wholly irrelevant because they've never even asserted that these 1 and 2 digit numbers are those. So any documents they have that would correlate those 1 and 2 digit numbers to name and badge number, they should have turned over and are not exempt.
Well, I think, may I ask you a question?
Please.
Excuse me, may I ask you a question?
Please.
As I understood what the city was saying was police personnel were authorized to use by that memo that, as you noted, did not really respond to your request because it didn't give you the documents you wanted, but that memo said police officers have been told to use a particular number in lieu of a name tag. Am I correct? Is that what that memo said?
Yes, Your Honor.
And you're saying that even though that was the memo that you got, and that was that in fact you believe that the officers were wearing some other number?
Yes, Your Honor.
Okay.
Because I know from other public records requests and sort of an extensive investigation, and I guess now the city's admission, that PERNers, which are the numbers that memo referred to, are 6 and 7 digit numbers, not 1 and 2 digit numbers. And I saw 1 and 2 digit numbers at the recent demonstrations, which prompted me to ask to send that request in.
I see. So you're asking me to decide that your initial request was broad enough to cover whatever numbers were being used, not just these PRN numbers.
Correct, Your Honor.
Okay. And would the city, okay, but at least right now, we don't know what those 2-digit numbers are because evidently you there is some constraint on you revealing that.
Apparently so, Your Honor, yes.
And Your Honor, I can interrupt, and I'd be happy to.
Well, sir,
for the sake
sir,
of...
Mr. Rodriguez, I'll let you talk in a minute. I'll certainly have questions for you.
Apologies. Okay, thank you.
So would you like me to continue, Your Honor?
Yeah, yes, please do.
Yeah, so that's my first argument, that the exemptions they cited are wholly inapplicable to the secret 1 and 2 digit numbers. So to the extent those were used, those documents should have been turned over. My second argument is that the statute, both the city and the district attorney very conveniently omit the word card almost everywhere they write employee issued identification card numbers, except when they directly quote the statute. Otherwise, they omit that word. And fundamental principle of statutory construction is that words aren't extra. We don't just take them out. The city's only argument in its response, its reply to that, was that there's another exemption that exempts the card itself, so a copy of the card itself. That doesn't mean that a list of identification card numbers couldn't be separately exempted. And in fact, that would be necessary because if the exemption that exempts the card itself, that would protect the card itself. It wouldn't necessarily protect all the components if they were incorporated in other records. It's a very narrow exemption, and the case law is clear that the public body has all of the burden of proving an exemption. That burden is daunting. The exemptions need to be read narrowly, and if there's any plausible interpretation that would allow for disclosure, then that's the interpretation that should prevail, because the Oregon Public Records Act, by the policy of the Legislative Assembly, is not a secrecy act; it's a transparency act. So,
well, I certainly agree with you as a general matter, but if you reveal the number from a card, you are in essence revealing the substance of the card, are you not? Particularly if the name associated with that number is also on the card, and that's exactly what you're asking for. You're telling them, give me the information from the card, I just don't want the card.
Except, Your Honor, in the circumstance.
I mean, I recognize you can read things narrowly, but you're also supposed to read things in a list to incorporate, well, in any case, you're supposed to read it to make sense. And if I read it, it strikes me, and I'll let you speak to why I'm wrong in a minute, but if you're asking for, if you had said, please give me all the information that appears on any personnel identification cards, including the name and the number on each card, just don't show me the card. And if the city perchance happened to have a document that had that on it, and you're assuming that it does have such a document, then you're the one that is ignoring the purpose of the exemption, isn't it? Tell me why that doesn't work that way.
Your Honor, that doesn't work that way because there is no card. In the current circumstance, there is no employee issued identification card. The numbers are pure database numbers that are associated with the accounting system at the City of Portland. They don't use the word card every time they make their argument because there is no card.
I see. Okay.
So the city's interpretation is that any employee number is exempt, whether or not it's on a card. And that can't be true because we know that officer badge numbers, which are employee numbers, are not exempt. Many employee numbers are not exempt. That statute is narrowly focused on employer-issued identification card numbers. The city would like you to stress numbers rather than card, but I don't think you can throw card out, Your Honor.
Okay.
Did I address your question squarely?
I recognize when I read the city's argument that they seemed a little allergic to that word, yes. So rather than spending all this time, why don't you just file another public records request, which they have only a few days to respond to, saying, please provide all documents correlating the numbers that police employees were wearing to their names.
Your Honor, the reason I don't do that is at the time that I asked the request, that's what I meant by my request. I think that those are the numbers that were being used are internal personnel numbers. They may not be PERNers, but there's some internal personnel numbers, and they were being worn in lieu of name badges by officers. I was careful in my language. And if the city can parse words and play word games and make me sue them and take a year before I learn enough information to rewrite the request, then sure, there's a short window on the request itself, but the Public Records Act means nothing. The answer to that, Your Honor, is legally I shouldn't need to. I've already asked for this information, and it's been withheld contrary to the law, and it should be provided under my original request.
Okay. You have anything else you want to add before I let the city respond?
No, Your Honor. I think those are my two arguments. I guess the last point would be that if there is not an employee identification card, employer issued identification card, then the whole rigmarole about having to go to another statute and prove, 192.363, that's simply not applicable. So all of that argumentation falls aside if this exemption is not applicable to PERNers, which I believe it's not because they're not on a card. Thank you, Your Honor.
Okay. Counsel for the city.
Thank you, Your Honor. So I'll just start by bringing the issue back to the issue before Your Honor today, which is internal personnel numbers, which are in fact PERNers. And Mr. Kessler alleges that the city violated ORS 192.329 because supposedly the city unlawfully withheld certain records. But we followed, if you read the statute 192.329, we followed that exactly. Subsection 2B states that a public body's response to public records request is complete when the public body asserts any exemptions from disclosure that the public body believes apply. That is what happened in this case. Given the processes, the city received the public records request that you read in its entirety already, Your Honor. The city evaluated it on its face with its reasonable meaning, interpretation, giving what the request says, internal personnel numbers, and the context of PPV's policy announcement that they were using, authorizing officers to use PERNers. That was the reasonable interpretation. And therefore, the city asserted the exemption under 192.355 subsection 3 in accordance with.
Okay. let me interrupt you there.
Yes, Your Honor.
I don't really care too much about what you may have said to Mr. Kessler in settlement discussions, because I would have this question even if it hadn't been discussed in settlement discussions. I had assumed that this, I mean, I did understand from all the briefing that there were 6 or 7 digit numbers that are these personnel numbers. But I also understood from the briefing that at least early on, members of the police were putting some other number on their helmets. And I have to say that I assumed that that was simply an action by individual police officers who just thought, I'll put a number on my helmet. That'll be fine. It's not 6 digits, but at least I have a number on my helmet. Are there internal personnel numbers, 2-digit personnel numbers that police officers, to your knowledge, were using? Because if so, then if you didn't reveal those, then you didn't respond to the request. Are there internal personnel numbers that at least once were used in lieu of badge numbers or name tags that are not PRN numbers? And if so, were you as counsel aware when you responded, or when the city attorney's office responded to this request, were you aware that there were other internal personnel numbers that had been used by some officers, but you just decided not to respond to that request?
To answer your question, Your Honor, the policy at the time that Mr. Kessler's public records request was made was the policy that per Commander Hurley's email memo, which was officers are authorized to use.
I don't care about the policy, Mr. Rodriguez. I'm asking you the response to the request, which was for internal personnel numbers used in lieu of badge numbers. And Commander Hurley, or whatever the proper title is, told her officers to use a particular kind of internal personnel number. Sure, that makes sense. But this request may have gone to the city attorney's office, but the police bureau knew or did not know that there were other internal personnel numbers used in lieu of employee identification numbers. That's what I'm asking you. Did the police bureau allow officers, or was the police bureau aware that certain officers were using internal personnel numbers other than PRN numbers in lieu of badge numbers or name tags when they told you how to, or when the police bureau decided how to respond to this request?
So, Your Honor, the request was made to the city, not the police bureau. And to my understanding is that the city, when it responded, was only aware that officers were authorized to use PRN numbers, not these 1 or 2 digit numbers that later on, and we can go into this certainly because it's relevant, but that later on, whether PPB changed its decision or some officers started to use 1 or 2 digit numbers, that happened independently and perhaps and subsequently to the request. At the time the original request was made, the request was for internal personnel numbers, and we even responded with that memo correct? And then at the time of the request, I need to point this out, and subsequent information, Mr. Kessler never made a mention of Officer 12 or submitted a picture of Officer 12 or request or specified 1 or 2 digit numbers. So no, the in good faith and reasonable interpretation was that he was seeking Perner. That's the same basis that the DA, the district attorney, made his decision on. Reading the same statute, employee issued identification card numbers as the city, as we briefed, emphasis being on the numbers, and we can go into a little bit more of that if need be.
Well, okay, all right.
Mm-hmm.
As I understand it, I'm going to interrupt for a moment here because I have a lot of paper in front of me. The amended complaint has a picture of somebody on page 5, and it alleges that the officer is wearing a piece of white tape with the number 12 written on it. So certainly, at least at the time of the complaint, and I think Mr. Kessler said that he submitted this photo to the district attorney. So what does the number 12 designate? Is that an official number, or is that just a number that a police officer decided to put on his uniform because he was told to put numbers on it?
So, Your Honor, so to clarify, in Mr. Kessler's complaint, yeah, he does state that he submitted a picture with the DA, his appeal to the DA, and that was the first we heard about or saw reference to a picture of Officer 12. And still at that point, I'm not sure.
Just let me clarify that.
Yeah.
Was this photograph submitted to the district attorney?
That's my understanding, yes.
Okay.
Okay.
So, and did the city attorney's office respond to the appeal? I know that the police union did. Okay. And
Yes, Your Honor, the city attorney responded to the appeal.
okay. And you said we have these PRN numbers. Number 12 can't possibly be a PRN number because PRN numbers are 6 or 7 digits, as I understand it. So it wasn't later that anybody knew. It wasn't later in the summer that people started wearing numbers on their uniforms, 2-digit numbers. It was very early in the protest. It was in June, as I understand the record. And when you responded to the appeal, you talked about PNR numbers. Now, I don't think it's confidential, and although it is not officially part of the record, and you therefore can refuse to answer if you want, are there 2-digit numbers that the city uses or the police bureau uses that are some sort of internal numbers? Internal personnel numbers, 2-digit internal personnel numbers?
So to answer your question directly, now we know that yes, and so certain RRT members at times
I don't know what
later,
that means.
Sorry, so rapid response team are the what was formerly the volunteer unit within the police department that were handling a lot of the protest crowd management aspects. or crowd control.
I see.
And so my understanding is that the policy was they could use perners, and that was the initial policy. And later on, I understand that they changed that for some officers and using one or two digit numbers instead of their perners or instead of their names. At the time this request was made.
So this officer wearing number 12 in June of 2020 was in violation of City Police Bureau policy. Is that correct?
For what, Your Honor?
He was wearing 12 instead of a PRN number. You said later on, people started using two-digit numbers. But in fact,
speak to whether.
All right.
I can't speak to whether he was in violation of that policy or not at the time. What it is important to also note, and for full disclosure, and I'm happy to go into this now, we did earlier this week reach out to Mr. Kessler in an effort to say, look, we now understand that you may have been actually seeking these other numbers. Why don't you make a new public records request or an actual seeking what you're actually seeking, because you stated that you're not actually now seeking these perner numbers. And he did not want to do that. It's also important to note that officer number 12 in a separate public records request, the city has provided the information of his identity, even including his perner number.
Discussions that need to be excluded.
And I think I have the ability to waive that as the one who called it, right?
No, that's okay.
But that wasn't actually part of the settlement discussion.
Just so we understand, let's go back to the RRT numbers, which we now know were worn by some RRT members during at least some protests, and they are different than the PRN numbers. Are those considered internal personnel numbers for purposes of the statute?
No, Your Honor. And so the city the city has never claimed that any, as plaintiff earlier mentioned, Mr. Kessler mentioned earlier in this conversation, that he said that the city is not, we're not asserting that any employee number is exempt. We're saying that perner numbers are exempt. And we understood his request to be perner numbers. And if you go through the entire record, I can cite all the mentions of perner numbers or employee issue identification numbers or numbers that both plaintiff, the city, the DA all used, and it's only starting to talk about specifically expressly talking about 1, 2-digit numbers and saying that these were like towards the end of the briefing. And so the entire record is actually really emphasizing perners and employee identification numbers.
I understand what the argument appeared to be before Mr. Kessler filed his response to your motion. Yes, people were talking about perner numbers, but in fact, well, we'll leave it there. So now we have these other numbers that were in fact mentioned in the appeal and in the complaint, but we'll let that slide for a moment. Are you telling me that these numbers are not internal personnel numbers? If they are, you just claim an exemption if you ask for them.
Sorry, can you repeat that, Your Honor? Sorry.
The RRT numbers, if those are internal personnel numbers, and I were to order that they be released, you would appeal my decision by saying these are internal personnel numbers that are not subject to disclosure, right?
No,
And
Your
you'd
Honor.
appeal that.
We would not. The RRT numbers that are, my understanding later on, is that those are not internal personnel numbers. Those are bag numbers associated with certain RRT members, and that's what they were using. And we would not claim an exemption under 192.355 for those, because we don't consider those as the sensitive private information as the PERNer, which is what we understand the legislator wanting to have protected. We wouldn't appeal or claim an exemption for these RRT bag numbers, because in fact we have provided some of that information in other public requests to plaintiff, including officer number 12's PERNer, because through DA guidance on that request, he stated that there was a clear and convincing standard that the city could use as a guide. So therefore meeting the statutory requirements under 192.363 to disclose that information. And we did for officer 12. So plaintiff now has officer 12's records, his name, his PERNer, and we were just asking for the same level of direction or of statutory, application in an individualized manner for other officers, if that was the case, because the way we read his request was PERNer numbers for just, it was broad, right? Blanket, Portland Bureau police officers, not, I know he inserted in brackets in his response the May-June timeframe, but not even in his request did he point out a specific time frame. And
his initial request, which I had in front of me just a minute ago, was for numbers, internal personnel numbers used in lieu of badge numbers during the recent demonstrations. And I guess we'll all acknowledge that the recent demonstrations were last summer. So, and you just said to me that you have released information on an RRT number because you believe that the standards met in 192.363 were met. Is that what you told me?
Yes, Your Honor, per guidance from the district attorney. That's correct.
Okay.
Your Honor, I believe it was
So
a
you do-
PERNer that you said it was disclosed.
So you do consider our team numbers to be protected by 192.363, is that correct?
No, Your Honor. The issue there was that as part of officer number 12, which number 12 being the RRT number, there is records that were released because the number 12 was not, we weren't claiming an exemption for that number. But
Okay.
part of his records included his PERNer number. So we first redacted the PERNer number. My understanding is plaintiff appealed that. And then per DA guidance, we subsequently unredacted the PERNer because,
I see.
yeah, correct. Mm-hmm.
Okay. All right.
And can I say one more thing, Your Honor?
Of course.
And
Please do.
so the thing we would essentially appeal is, because this seems to be a non-existing request. If he's asking for what he meant by numbers being this blanket list of any number, any number that's used internally, then that would be a completely different request than the one we evaluated, the one we processed. And therefore, because that is a non-existent request and because there's been no denial of that request, then if what plaintiff is now telling the court and what we're understanding is a different request, then it would essentially be moot. As I just wanted to put that out there.
Well, I understand, and you may have been ill-informed by the Portland Police Bureau. Although it strikes me that these RRT numbers used in lieu of badge numbers sort of sound like employer-issued identification numbers used in lieu of names or badge numbers, but I'll think about that. So let me ask you, I have to say I found, and I'll put it in a sort of an aggressive question. I found your argument asking me to ignore the word card underwhelming. And the reason I say that is your argument was the emphasis in the statute is on the word numbers rather than card. And a reason, and you may have more to say about this, and that's what I'm asking you for. The reason I say it's a little underwhelming is because I don't know how to determine in a statute that uses two words without italics, which word is more important. So Mr. Kessler says you've essentially read a word out of the statute, and you say, oh, no, we're just saying that word isn't as important as certain other words. So do you have anything to add to that argument that might persuade me that, yeah, employer identification card numbers include employee-issued identification numbers, even if they aren't written down on a card?
Yes, Your Honor. So that statute, right, the exemption that we're asserting applies to internal personnel numbers or PERNers, says that upon compliance with 192.363, public body employee or volunteer, residential addresses, residential telephone numbers, personal cellular telephone numbers, personal electronic mail addresses, driver license numbers, employer-issued identification card numbers, emergency contact information, social security numbers, date of birth, or other telephone numbers, and this other key phrase, right, contained in personnel records maintained by the public body. Now, what the legislative history points to and the relation of this list is that they're all sensitive or private related numbers, essentially. And the PERNer is the primary employer-issued identification number for the city. Now, yes, I do read in terms of the construction of that phrase, employer-issued identification card numbers, numbers being the last word in there, it's the numbers associated with employer-issued IDs, right? And the statute's general emphasis, again, is the private numbers contained in personnel records. Now, PERNer numbers are contained electronically in the city's Human Resources Information System, which is the primary repository and management system for personnel records. Plaintiff argues that the exemption doesn't apply because the city hasn't shown evidence of a physical card, right, incorporating the PERNer numbers. The city employee physical cards that plaintiff may be referring to are not contained in the city's personnel record stored in HRIS or SAP. Those badges are simply to be able to access a city facility. And in fact, the only number associated with the card is used by the city's OMF facilities or Office of Management and Finance Facilities Bureau to track, freeze, or inactivate access to city facilities, and that's it. It's not tied to any other information. It's certainly not stored in your personnel record. The numbers, stored within the HRIS. And so given that...
Let me ask a question. I'm sorry to interrupt, but so city employees have some sort of cards, city employee cards, but those cards do not reflect, if I looked at one of those cards, it wouldn't have a PRN number on it. Is that what you're saying?
That's correct.
Okay.
And
all right.
Furthermore, there's already a statute, a separate public record statute that protects the card from being disclosed. And so that's also, and given the legislative history for the statute at issue, for the exemption, given that it's trying to protect the sensitive information, and that there's a separate statute already protecting the card itself, it's clear that what the legislator meant was the primary internal employee issued identification number, internal personnel number, which is the PERNer.
Yeah. So, so somewhere in this, you're telling me somewhere in the computer system of the city, there are names of employers in each of those, or employee, and each of those employees for some purpose at the city has one of these numbers associated with it. Is that correct? One of these PRN numbers?
Correct.
Okay. And the city uses those numbers for what? Do you know?
The PERNer number? Yes, the PERNer numbers are essentially the organizational equivalent of an individual social security number. So it's the number that...
an internal social security number.
Correct.
In essence.
Yeah.
So the city can track what employees are doing what, where.
The PERNer number, correct.
Is that correct?
That one, yes, the PERNer number is exactly that, and it's tied to payroll, it's tied to your social security number, all sorts of information that's held in your contained in the personnel record, which is the words used in the statute.
Yeah. Okay. So if you were, and I'm not saying I'm going to order this because of my tentative decision, if you were to release all the PRN numbers to the Willamette Week, they couldn't do anything with them anyway, could they?
Not necessarily.
If they had Mr. Rodriguez, PERNer number such and such, it would be mere gobbledygook.
I'm not sure I fully understand.
Well, if Mr. Kessler had all the PRN numbers of all the police officers, I mean, what he really wants is the names of police officers, right? But if he had all the PRN numbers and all the police officers, that wouldn't give him their social security numbers or home address, any of that. He would have to do further research to do that. But I think that you are making the argument that once we release all these names associated with the numbers, that the names themselves will be used for potentially harmful or improper purposes. Is that right?
So the PERNer being a very private number tied to payroll, tied to pension, tied to Oregon public employees, that's a very sensitive number. And I'm not an expert enough in cyber attacks or doxing to know the level of access that someone with malintent or malicious intent could use that number for. But there's serious privacy concerns to the point that the legislator included it in 192.355 because of privacy concerns.
Okay.
Now, we're not saying that the names are exempt themselves. Those are, I mean, Mr. Kessler publicly through his Twitter has shown that he has ample and vast lists of public employee police officers' names.
Okay. Okay. I have another argument. It's probably waiting on the line.
And the point is, Your Honor, that the plaintiff has the record that we now understand that he was seeking in the first place. And so that's important to mention.
Okay.
Excuse me?
Okay, Mr. Kessler, I have a couple of questions for you.
Your Honor, I disagree with that last representation. I do not have the records I had asked for.
Okay. So you believe that the records you asked for, and I'm not judging that particular question right now, but
yes, Your Honor.
It is your assertion and belief that when you asked for these records, they necessarily included the names, what we now know are RRT numbers, and that you were asking for the names associated with RRT numbers. Is that correct? These two-digit
Your Honor,
numbers?
I was requesting at least that, Your Honor. I, of course, only had a peep into what was going on the ground. I didn't see everything. The city alleges that also perners were being used on the ground. So I would ask they be stopped from denying that at that point. So
okay.
At this point, I think that perners and RRT should be disclosed.
Does your request encompass both what we now know are rapid response team numbers and Perner numbers?
I believe so, Your Honor.
Okay, so that it's your request would encompass all of that.
Yes, Your Honor.
Pardon me?
At the very least,
okay.
That's an outstanding question of fact. If you have to get into which ones were specifically worn, although I think the language could be interpreted, more broadly to include everything that could have been worn.
Okay. Okay, I understand. Right. Any number that somebody is wearing in lieu of such and such is what you thought you were asking for. What you now say and what you say that you thought you were asking for. Yes, I get that.
Yes, Your Honor. And
okay.
May I respond very briefly to a little bit of the discussion?
Yes.
I think it's important to know that opposing counsel on this call is the new person at the office, and I don't envy him being thrown into this hearing. The city attorney, Jennifer Johnston, was handles public records at the city of Portland, was handling this, was well aware that I was looking for Brent Taylor because I'd asked for in a lot of different records requests, was well aware because she got a copy of my appeal that included that photo. And I don't believe it was a particularly forthcoming representation that the city made to the district attorney by talking about perners and pretending like they didn't notice this Big 12 on the officer's uniform. I think it's outrageous that it's only at this hearing that I'm learning officially about RRT numbers. That should have been part of the discussion during the appeal. And the city did that not to promote the purposes of the Public Record Act, but to obstruct access to information. Thank you.
Okay. Gentlemen, I need to move on to my next argument. I appreciate the thoroughness with which you have thought about this and provided me the information that I now have, which I did not fully understand as I read the papers. And as I said, I don't make decisions from the bench, and in particular, you have given me much to think about. And so this case is submitted for my consideration and ultimate decision. Within the next few days, I will send a letter to council explaining whatever my decision is. Typically, so there isn't a lag in time, I email a copy of my letter decision to the council, followed by a hard copy. And so this case is now submitted, and unless there is something more other than additional argument, which is now ended, we will close the record on this case. Thank you very much, counsel.
Thank you, Your Honor.
Thank you, Your Honor.
I don't need a paper copy for the record. Thank you.
Okay.
Okay. Thank you. Bye.
Okay, Sage.